This conference will now be recorded.
So we're going to go ahead and get started, Mark?
It's largely up to you, Kristen. I'm happy to start whenever you are. Based on the attendance sheet, we should have a few additional people joining within the next couple of minutes.
Sure. We do have a lot to cover this morning, so I think we'd probably better go ahead and get started.
Okay, let's do that then.
Okay, welcome everybody to today's meeting of the Judicial Review Committee. Our topic today is agency litigation web pages. First, I want to turn over the floor to our Vice Chair and Executive Director, Matt Weiner, for some opening remarks.
I think that I'm going to turn my opening remarks. I think, Kristen, will be to turn it back over to you so we can get started here.
Okay, are we having any problems with the recording since that's the second time I've heard that message?
Everything appears to be working.
Okay, just making sure. So before we get started, I want to remind everyone of the basic rules under which we're operating. ACUS members, their designated alternates, senior fellows, liaison representatives, and special invited guests have full speaking privileges and are able to unmute themselves. To avoid background noise, I would ask that you keep your microphone on mute and either add a comment in the chat feature or physically wave at me if you would like to speak. I will keep a queue and call on you, and you can then unmute yourself. And then when you're done speaking, please remute yourself. That'll just make this, that'll cut down on the interference given all the technology. For members of the public, please use the chat feature to indicate if you'd like to speak. I will turn to you at an appropriate point in the meeting if we have the opportunity to allow you to speak, and the ACUS representative running GoToMeeting will unmute you at that time. You'll then be remuted when you are finished speaking. Please be aware that our rules generally provide for ACUS members, designated alternates, senior fellows, liaison representatives, and invited guests to take precedence in the speaking order. So I would ask members of the public for their patience when waiting for their turn to speak. But if you will signal in the chat feature that you would like to speak, we will do our best to make sure that you have an opportunity to do so. In the event that we need to vote, please be aware that only members of the Judicial Review Committee, which includes government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsel, those are the only people who have a vote. Please do not vote unless you are a member of the committee. Mark from ACUS and I both have lists of committee members in case you're unsure of your status. If you are unsure, I would recommend that you flag Mark either by email or in the chat just to confirm your status. Regarding the chat feature, please refrain from posting substantive comments or questions in the chat area. It can be easy to miss something as it scrolls along, and the chat is not saved in the GoToMeeting platform. So we would prefer that you not post substantive comments or questions there, and instead just use the chat area to signal that you have a comment or a question that you wish to share. Before we get started, I also want to take just a few minutes to remind everyone of where we stand with this recommendation. We have had 2 prior meetings at which we've discussed this recommendation. At our last meeting, we worked our way through the edits to the recommendations themselves, but ran out of time before we could address the preamble. Over the past 2 meetings, concerns have been raised in particular about the potential costs of the recommendation, as well as its being more feasible for some agencies than others, and consequently, we have approved edits to make the recommendation more flexible and to give each agency a tremendous amount of latitude in deciding for themselves whether adopting a litigation web page is right for them. Since our last meeting, with the committee's approval, we have conferred with and received additional suggested edits from the Department of Justice, and we have also received other feedback from other agencies as well as from Allen Morrison and the American Association of Law Libraries. So let me say that some of this feedback is enormously enthusiastic and pushes us to expand the proposal, while other of the feedback is markedly less enthusiastic and seeks to water down the proposal further. The trick, I think, for us is going to be to find the right balance in the middle. All of the suggested edits have been distributed to members of the committee, but I want to thank particularly Mark for taking the time to compile them all into a single red line document so that we can discuss them collectively in an orderly fashion. We really appreciate the amount of effort that people have put into reviewing this recommendation, but all of this consultation and feedback means we have a lot to get through this morning. So we're going to start with the recommendations, and then after that we will return to the preamble. Mark, can you think of anything I have missed with these opening remarks?
I cannot.
Okay. Then with that, if everybody would please turn to the recommendation, which on the red line that was distributed this morning starts on page 5. So our very first comment that we are looking to on page 5, it's marked as A14, comes from the American Association of Law Libraries and recommends adding, I guess at the start of the recommendation, we encourage agencies to consider the cost of creating and maintaining agency litigation web pages, including the resources needed to keep their web pages up to date when developing their agency budgets to support successful implementation. I'm open to, let me get my chat open here. Bear with me momentarily. I'm opening the floor to questions, comments, or concerns about this particular suggestion. I've got my own thoughts, but I want to give other people a chance to express theirs first. Anybody? I will say that to my eye, I think that this particular concern has been, I'm sorry, so there's feedbacks from, I think somebody just joined. If you wouldn't mind muting yourself to prevent that feedback, I'd appreciate it. To my eye anyway, I think that the recommendation or the suggested edit is reflected in other aspects of the preamble as well as the recommendation. So I'm not sure that it necessarily adds anything, although I appreciate the sentiment. So I'm looking to hear if anyone disagrees with that. Seeing no disagreement, I think we'll just move on and not take this particular recommendation. Okay, turning the page. So in recommendation number 3, the Department of Justice has suggested that we add a couple of items to recommendation number 3, which lists various factors that agencies should consider in determining whether to provide access to agency litigation materials and determining which types of agency litigation materials to include. The first item, which is the new item C, suggests considering the availability of other technological services that may more reliably and effectively give access to this material because of its scale or volume and the wide variety of issues and matters involved. Is a representative from DOJ with us today? Sure, welcome. So can you tell us what other technological services you were thinking of in this regard?
Well, we've talked about this a little bit, but just to put this one in context, certainly there's Westlaw and Lexis. We've discussed Pacer and agencies that have tremendous amounts of litigation, like the Department of Justice, or even the IRS, have so many cases that they need advanced search abilities to be able to make any sort of productive use of any sort of research that might be done. And this takes that into account.
Thoughts or concerns from other members of the committee?
Kristen, this is Don Elliott. May I?
Absolutely. Please go ahead, Don.
Yeah, I think this is a good idea, but I would suggest that we add cost as availability as well as availability. So agencies should consider both the availability and the cost of other technological services. But I support the idea of adding this.
I don't have any we don't have any objection to that. That's fine to say cost. Sure, of course.
I think perhaps cost should go before availability. I think that was Don's suggestion, if I heard him right, although maybe I've gotten distracted and lost touch.
I don't really care one way or the other. I think you consider availability first and then cost, but I don't feel strongly about it, Kristen.
Okay. I have no objection to cost coming after availability. That's fine. I just want to make sure everybody's suggestions are accurately reflected. Other thoughts, comments, concerns? I will admit that I had a bit of a concern myself, but I think my concern has been satisfied by Don's suggestion of including a reference to cost in here. I think one of our concerns throughout this, the consideration of this recommendation in general, has been the relative inaccessibility of Westlaw and Lexis and Pacer for people who do not have the financial means to or organizational availability to sign on to those different subscription services. So I think reflecting cost sort of mitigates that concern, although I take the point about there being other services that are available out there. Okay, the next suggestion is a new item at the end, which now, with the addition of item C, a new item C would become item I. The risk that publication of the agency's litigation materials without private litigants' positions or court opinions may promote public confusion or misunderstanding. I will make the observation that we have included court opinions in the definition of agency litigation materials. So consequently, including the phrase or court opinions, I think is inconsistent with the recommendation generally, and the fact that we've included court opinions among the materials that agencies are supposed to include on their litigation web pages. So does anyone object to our removing or court opinions from this particular suggested language? Brady, go ahead.
Yeah, I recognize that it's included in other parts of this document, but this number 3 is a specific list of factors that an agency should be considering, and I think it's worthwhile to have that in front of them. Certainly, how the court decides a case is relevant to understanding the agency's position on something, especially if the agency was wrong, or, well, actually, even if they were right, it's good because the court opinion gathers everything together, and I think if we're saying it's one of the factors they should be looking at, I think that's appropriate.
Well, but Brady, we're already saying that they should publish the court opinions on their website by including it in the definition of agency litigation materials. So the way that it's worded, this says the risk of publication of court opinions without court opinions may promote public confusion. That doesn't make any sense internally as a matter of drafting. You following me?
Yeah, I'm following you. That's a good point. Okay, I withdraw my objection, or I withdraw my comments. It's fine.
Great, I appreciate it. It looks like Andrew Vollmer would like to make a comment. Please go ahead, Andrew.
Good morning, everybody. I have some concerns about adding this factor here. First of all, it assumes it's written in too negative a fashion, and I think it's in the wrong section of the recommendations. My preference, although I want to make sure everyone understands, I have been a proponent of having our recommendation refer to the inclusion of opposing party filings on the website from the beginning. Not everyone, just when necessary to understand an issue or for balance. So that's my starting out position. But there are a couple of additions from DOJ that I think are written in a backwards fashion. They're written in a very negative way. And this is one of them. I don't think we want to talk about the risk of promoting public confusion or misunderstanding. What I like people to consider is when we come to paragraph 5, which is the things that should be included on the website, I think that there should be a specific item about opposing party filings when necessary for a fair understanding of the issues. And so I would like to put things more positively. And so I don't like this item here, not that I oppose the concept, I just think it's written in a backwards way.
Brady?
Do you have a constructive proposal beyond it's too net? Do you want to write it a different way, or do you want to insert it in 5?
Yeah,
I
proposed, I thought, a constructive solution. I would like it to go in 5, a specific factor for agencies to consider is to post opposing party filings when they are significant or important to understanding the issues.
I think when we get to 5, and we actually, the DOJ had proposed in a positive way adding that factor in there. I don't know if you saw that red line in there. E, I think it's highlighted right now on the screen.
I did, and so I favor that. But I don't think you need both 5E and the thing we were just looking at.
Right. If we end up including 5E, I don't have an objection to removing 3I, taking into account your observation that it is a little bit different in tone than the A through H.
Yeah, and I would revise E. I mean, it's just my personal preferences. I would try. So first of all, I appreciate that it's positive, so that's a good thing. But I would make it more general rather than so that public sees both sides of an argument, although I agree with that. How the litigation is resolved, we've already talked about court opinions being part of the items that should be posted on an agency's website. So I agree with that. But I would prefer words to convey the idea that not all opposing parties' filings need to be included because there's a cost concern and a complexity concern to that. But just to say, consider posting opposing parties' filings when they are, my language was, when they are significant or important to understanding an issue. So it gives some discretion to the agency. But I agree, I would like to call out opposing party filings specifically as a positive factor to be considered.
I'm sorry, nobody heard what I just said. I get that we need to mute people, but it's going to be, if I'm going to be leading the meeting, if we keep muting me, that's going to be really, really complicated. So why don't we just leave me unmuted if that's all right? What I was saying was the next item on our list is item 5. So why don't we talk about 3I and, eliminating 3I and whether the modifications to 5E we can go ahead and resolve that question. But before we get to that, or perhaps as part of that, Steph Tatum had a comment. So Steph, please go ahead.
I just wanted to speak in support of Andy's point. I think that's absolutely right. I also felt that the framing in I was a little bit negative, and it might lead folks away from posting materials because they didn't want to create confusion. I felt like it was a little bit strong, and I prefer the formulation below. And I thought that the edit below was also helpful because it fixes the same issue that you already identified of encouraging people to post court opinions, which, you know, we've already encouraged them to do definitionally.
Okay. Other thoughts, other comments? I mean, it seems if I'm catching this correctly, Andy and Brady, it seems as though at least you both are happy enough with eliminating 3I with the revised language of 5E. Is that correct?
Yeah, there's Vollmer. Yeah, that sounds fine to me.
Wonderful. Brady?
Subject to how we resolve 5E, but it sounds like we're on track to a constructive solution.
Does anyone have any objection to the revised version of 5E? It reads, you know, so 5 collectively, it's a new recommendation in total that agencies should disclose materials in a way that gives a full and accurate picture of their litigating positions to provide context and avoid the appearance of selected misleading or the improper presentation of agency litigation materials. Agencies should, and then there's a list of considerations. 5E now reads, consider posting opposing parties' litigation filings when they are significant or important to understanding an issue. Is that acceptable to everyone? I mean, I guess one question is, does anyone have an objection, at least in principle, to the addition of recommendation 5? Okay, I'm not hearing any. You know, does anyone have any other suggestions for changes to 5? I guess there are a few that are proposed here by ACUS staff, so why don't we go ahead and go through those? Generally speaking, it seems like there's agreement in principle with including item 5, but at least, let's see, with respect to, if I'm reading this correctly, not the world's greatest at reading red lines. With 5D, ACUS staff suggests omitting this language because opposing counsel briefs are not included within the recommendation's definition of agency litigation materials, and because court opinions are already included with that definition. So it's the including, if D is explain the types of litigation in which the agency is involved in other ways to search for agency litigation materials, it's true that at least as a doctrinal point, or not doctrinal point, as a matter of drafting, opposing counsel briefs are not part of the definition of agency litigation materials. So it wouldn't make any sense to say including opposing counsel briefs. Meanwhile, court opinions are part of the definition of agency litigation materials, so that language is redundant. Drita, I understand you've been raising your hand, and I apologize if I haven't seen you. I think you need to unmute. Drita, I'm still not hearing you, I'm afraid. Maybe try logging out and then logging back in, and maybe that'll fix the problem. Or maybe Jennifer, you can try working with Drita. In the meantime, Brady, I saw your hand, so let's go to Brady.
Thank you, Kristen. I take the point about the redundancy, but one of the things I'm concerned about is this idea that the agencies would post just their briefs on something, and this particular section is saying hey, when you're doing something like that, make sure you're taking into consideration that there are other documents, there is a court opinion, and it's something you should keep in mind when you're just posting your briefs, whether or not you need to also post the court's resolution of it, the court's opinion. So I don't think it's redundant. I understand your point about potential redundancy, but this is an area where I think as they're considering what to put up, the agencies should be looking at how the court resolved it as well, which makes it less redundant.
Well, I mean, I understand the point. To the extent that agency litigation materials is a defined term that does not include opposing counsel briefs, I think in order to avoid confusion, if we're going to include opposing counsel briefs with respect to this recommendation, I think at a minimum we need to change including to as well as, because agency litigation or opposing counsel briefs are not included in the definition that we have given agency litigation materials within this document. I suppose if you really want to, I mean, I guess, like I say, since court opinions are part of agency litigation materials as the document defines them, that does make this read other ways to search for court opinions, including court opinions. Hence the redundancy. I mean, if you really want to emphasize it separately, I suppose we could say including but not limited to court opinions, comma, as well as opposing briefs. Or opposing counsel briefs.
That's fine.
But it's very clunky then.
Maybe we get rid of the last clause.
You mean which part?
So that including opposing counsel briefs and court opinions, and say explain the types of litigation in which the agency is involved and other ways to search for agency litigation materials. I mean, that's for other agency litigation materials, maybe.
Well, if we use the same term, then
additional agency litigation materials.
Okay, so you're okay. Don Elliott's got a comment on this point. So Don, why don't you go ahead?
I wondered if we wanted to say selected opposing counsel briefs. I'm a little concerned that we don't necessarily want to have a flat rule that all opposing counsel briefs have to be made available. I do support the idea of making significant ones available. I think it's much more useful if you can see both sides. But I wonder if selected or significant, giving the agency some discretion might help.
Oh, I agree with you in general, Don. I will say this particular item 5D simply says explain the types of litigation in which the agency is involved and other ways to search for agency litigation materials. Victoria, do you have a comment to add here?
Yeah, I'm concerned about agency cost here. And to follow up on this, I do think significant is fine, but in the eyes of every litigant, every case is significant. So I would like to put in publicly significant, which is consistent with the proposal, because in fact, that will give someone an outside sort of standard, as opposed to the particular litigants calling up the agency and saying, you don't have my brief on your website. So that's what I would add. It's consistent with the original proposals. This is all precatory, but it gives you kind of more of a standard to limit this notion of significance to avoid harassment of the agency, essentially.
Could I make a comment?
Please go ahead.
wouldn't the word relevant be better than significant? Significant introduces some sort of judgment as to whether it's worth reading what these people have to say, whereas relevant is a judgment that we generally understand in the legal system.
Let me make one comment. I'm indifferent as between relevant versus significant. Let me make one additional comment before we turn to news. So I guess the question I have again, whereas I agree completely with the suggestion that agencies ought to consider making some opposing parties' filings available, I question whether this particular item 5D is the place to raise that point, because 5D in general is only talking about explaining the types of litigation in which the agency is involved and other ways to search for additional agency litigation materials. Whereas 5E then specifically talks about consider posting opposing parties' litigation filings when they are significant or important to understanding an issue. So my question for Don and for Victoria and others is whether they're particularly concerned about agencies explaining where parties can elsewhere find publicly relevant litigation filings by opposing parties.
Thanks, Kristen. I was back on E. I apologize. I mean, I agree with you. I'm trying to make them all consistent with public relevance or significance.
Sure.
I personally, so I'm trying to make it significant and also give somebody a bellwether about whether something is significant or relevant. Who's the audience here? So I apologize for the confusion about D. I think I was trying to comment on E and make it all consistent A to G.
Great. So okay, let me do this. Let's turn back to E, and I want to give Drita an opportunity to weigh in here. But first, Brady had said that he had no objection to limit or to deleting in 5D, that it was okay to go ahead and delete, including but not limited to court opinions and publicly relevant litigation filings by opposing parties, when we're talking about where else you can find things. Is everybody okay with that change?
Kristen,
Okay.
maybe just say, just as we're talking about all this, I'm now re-looking at it. I mean, the whole point of D is to say that an agency should, if someone wants to go further and look for other documents, the agency should explain where those things are available. So in light of our discussion, I propose adding just on the current D, adding and other ways to search for additional agency litigation materials and opposing counsel briefs, period.
Okay, what is out of curiosity with respect to additional agency litigation materials? Again, to the extent that agency litigation materials is a defined term that incorporates certain items, what are you? I think rather than using that defined term, we need to come up with a different. We need to be more specific about what additional documents you're thinking about. Why don't you think about that while we go on to Drita, who has been waiting very, very patiently. Drita, please go ahead.
Yeah. So I actually want to revisit. Can you hear me?
Yeah, I can. Thank you.
Terrific. I want to revisit the deletion of 3I. I'm getting a lot of feedback. Are you all here? Yes? Okay. So I know that it was presented in a negative way as a risk, but I think the point here is that the agency can, for example, just put all the things it considers relevant on the website and leave a very lopsided view on its website. The point, I think, is not that there's a risk, but there's an obligation for the agency to create or to present a balanced perspective, making sure that the public is well informed that it's not just the agency's view, but there are other opposing views. So that is, I think it's important. It lays the foundation and the predicate to put it in 3, so that when you do look at 5 to see the kinds of things that the agency might put on its website, it then makes sense. It's because it has an obligation to present a balanced perspective.
Good. Andy, go ahead. Andrew Vollmer.
Yeah, sorry, I just was finding the mute button. So we're all going to have such different habits about talking. So I strongly agree with the point that was just made, but I don't like the negative language, as I said before, about risks. And I have a proposal, which I hope addresses the comment, and which is the other negative addition that I saw here that I would really like to fix. And so I hope this proposal is a solution to some of the other that comment that we just heard, as well as others that have been made. So what I would suggest is, can we look at the introductory language to paragraph 5, because that also has a negative tone that I believe we would like to avoid. It talks about we want to avoid the appearance of selective, misleading, or improper presentation. Well, I of course agree with that, but I don't want to have ACUS do a recommendation that presumes that agencies are going to be inclined to do that. So I would like to phrase it in a more positive way, much like the comment we just heard. So my proposal, which I hope takes care of the comment we just heard about 3I, because I'd still like to strike 3I, is to have this introduction to paragraph 5 read, to provide proper context and a fair, balanced, and neutral presentation of agency litigation materials, agencies should. So again, my whole effort, so I agree with all the concerns and sentiments that people have expressed, including DOJ, but I would just like to put it in a positive way.
That would work. And incidentally, I wasn't suggesting that we keep the language in 3I as stated. I was looking to frame it positively as the obligation to create. And I like the fair, balanced, and neutral perspective. But I'm fine with 5.
I like that too. Other thoughts, comments, concerns in this regard at this point?
Judge Plager here. Can I make a comment?
By all means, please go ahead.
I'm basically in sympathy with Andrew's overall point, which is the tone, the repetition of first a positive notion and then a negative statement of all the reasons why we want a positive notion seems to me not helpful. Simplicity would help this whole document. So let's look at 5, and we keep moving around, so I'm not sure what exactly we're on, but let's look at the language of 5, which starts out, agencies should disclose materials in a way that gives a full and accurate picture of their litigating positions. We don't need to then add a bunch of adjectives like fair, true, correct, lawful, relevant, important. All of that is of no help when we've already said what we want is a full and accurate picture of their litigating position. the next sentence could easily read, to provide proper context, strike everything out until you get to agencies should. Context does add a slightly different idea, so I would leave that in. To provide proper context, agencies should, da 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 da. And when you get down to D, explain the types of litigation in which the agency is involved and other ways to search for agency litigation materials, period. If you start trying to identify relevant or important or significant materials from other kinds of materials, you'll need a much bigger book than this particular document will provide. So my view is, if you're trying to communicate to the agencies some principles, stay with the principles. Explain the types of litigation in which the agency is involved and other ways to search for agency litigation materials, period. You don't need the including some things, because that implies not including other things, but we don't say which is which. So I vote for Andrew's basic proposition, which is stay positive and stay simple. That's me.
Rita, are you okay with deleting 3I if we make the edits that Judge Plager just suggested?
So again, I don't have a strong objection. I think the point I'm making is it's not just about educating the public about the agency's litigating position. It's about presenting the issue. We are one side of the equation and presenting the issue in a balanced way. I think that's what's missing for me. I mean, if we just present the litigating position of the agency in a full and accurate way, that I think misses the other side.
Other thoughts or concerns of, I mean, I guess what I'd like to know, I take Drita's point about if 5 just reads at the start that agencies should disclose their materials in a way that gives a full and accurate picture, and then says proper context, to provide proper context. I take Drita's point that there is really only emphasis on the agency's perspective in that regard. Although I will note that then 5E specifically references consider posting opposing counsel's pleadings. So perhaps provides that definition to exactly what constitutes proper context.
Yeah, let me make a point, if you would. Read the opening sentence to paragraph 5. Agencies should disclose materials in a way that gives a full and accurate picture of what? Of their litigating positions. We're not asking, or are we? Are we asking them to also represent the other side and make the arguments that the other side is interested in the litigation? I think that's a mistake. The agency is the last person I would go to get a fair representation of what the other side's argument is. I think what we can ask is that the agency give a fair representation of its arguments and its position. And I don't think they need to give a balanced representation of the whole litigation. That's what judges do. That's not what the agency does. The agency is a litigant, not a judge. So in your opening sentence to 5, you say, give a full and accurate picture of their litigating positions. That's what we're asking them to do.
Chris, and I have a comment on this point.
Please go ahead, Don.
Yeah, I was going to suggest that while I have substantial agreement with both of the last speakers, perhaps we could say agencies should disclose the issues in the case. Give a full and accurate picture of the issues in the case and their litigating position.
So before we add a lot to the opening language in 5, I guess one question I have is whether any of the items below, any of the enumerated items talk about the issues. I mean, I think we don't want to end up reiterating in the opening sentence to 5 everything that then is included in the itemized list. I also see hands from Brady and Andy. So Brady, please go ahead.
Thank you, Kristen. I'm not sure who made this point. I mean, as I understood this recommendation, one of the purposes of it was to educate the public, not to present a biased agency position on things, because of course they have an advocate. They advocate a certain view, and sometimes they lose. And the point of this section was to give context to it so that people aren't misled. And I know agencies try to do the right thing, but they don't always do it, and this should set it out. On 5D, I think it's important that the agency, as a backstop to all of this, tell the public how they can go out on their own if they're interested. If they start reading what's posted that the agency chooses to post on their web pages, then here are other places where you can find it. And I think, and Kristen, you asked me to look at this. I think it's important to say, and in the current language, to search for additional agency litigation materials, which I want to make the definition of agency litigation materials do some work here, because the agency is curating and just presenting a selected view of its materials and opposing counsel's papers, so that people can go out there and get the full context if they choose, if the agency hasn't done it. And I think it's an important consideration for agencies to have.
Okay, Brady, along those lines, what if we were to say any additional agency litigation materials not included on the agency's website? In order to avoid,
as well as opposing counsel briefs.
As well as opposing counsel litigation filings.
Fine.
Okay. Andy, well, we're going to end up making sure, I'm going to go down each one of these items one at a time and make sure everyone agrees after we get through all of this discussion. So I know we're bouncing around a lot and it can get kind of confusing, but they're all interrelated. So let's just kind of put up with the bouncing around for the moment. Andy, you were next in the queue.
I just want to register some disagreement with the idea that the agency's website is meant to be adversarial. It's meant to be one-sided. And so Brady made this point just a moment ago, and I strongly agree with it. And I do not like some of the edits that have been proposed. I'm a believer in purposeful redundancy for emphasis and clarity. So I would like the introduction to 5 to refer not only to proper context, but to balance or fairness. I use 3 words. I'm happy if we reduce that. We don't need 3 words, but I had fair, balanced, and neutral presentation. But I think that the agency and this website needs to provide the public an opportunity to understand. That's the goal. It's not just to understand the agency's positions, it's to understand what the litigation is about. And on occasion, that's going to require an understanding of what the other side said. And so that's one of the reasons I've been a proponent about including opposing party stuff. So in any event, I just don't want the last person to speak to prevail on some of these points when it's not clear to me that that's reflective of a consensus of this group. So maybe it is, and maybe nobody agrees with me, that's fine. But I would like to see the opening to 5 talk about to provide proper context and a fair and balanced presentation.
I agree with you. This is Brady again. I agree with you, and I agree with the recasting of this in a positive way, the way you did it.
Kristen?
Yes, go
Kristen?
ahead, Judge Plager, please.
Go
ahead.
Oh, okay. I think there is a basic lack of clarity in exactly what this document is supposed to be presenting. For example, look at the opening title under the word recommendation, providing access to agency litigation materials. Do we mean that, or do we mean provide access to materials in which the agency is involved in litigation? Those are two very different concepts. One concept says what we want is to know what the agency's materials are, that it's litigating. The other concept says we're asking the agency to now explain the nature of litigation in which it is involved and present fairly both sides, first identify the issues, and present fairly both sides of the arguments regarding those issues. Now, that's a very different proposition. I take it, the sense I'm getting from you all, at least some of you, is that what you really want is the agency to come forward on its website and explain why it's being sued, who's suing it, what their arguments are, what the agency's answers are, and perhaps even what the right answers are, although I'm not sure we should ask the agency to do that. But that's a very different question, and I'm not opposed to it. Don't misunderstand, I'm not opposed to that idea, but it's a very different idea than simply asking the agency to produce and report agency litigation materials. That's a very narrow concept. Can somebody please make it clear which it is we're doing?
I have to say that I agree with Judge Plager's concern here. I mean, I understand the point that several committee members have made, both at this meeting and in the past, about if the agency only provides its own litigation materials, then it's difficult to get the full picture of the litigation. On the other hand, we've also had tremendous concern about the cost that we're imposing on the agency, not to mention the logistical difficulties of recommending that agencies include certainly all opposing materials. I mean, we all get the idea that occasionally providing, in order to understand the litigation, you really want to see the full picture. But imposing that kind of a burden on the agencies to explain what's going on in litigation, to highlight the different issues, et cetera, I think is beyond the scope of what this recommendation was originally trying to accomplish, which is basic transparency on the part of the agency. I understand the concern about not getting the full picture if all you see is the agency's side. But if we tell agencies that they need to go out, that they need to present the full picture, I'm not sure any agency is going to be willing to step up and do an agency litigation webpage, because the cost, we've dramatically increased the cost and complexity. Robin Greenhouse has a comment. Robin, please go ahead. Robin, I'm not hearing you.
Can you hear me now?
I can, thank you.
Okay, so the comment I have is, there's a concern that the public would not be aware of what the issues are and what the other side, the third party, is arguing. Generally speaking, most court opinions do lay out the issue and identify the major contentions that both parties are making. So if we're including in this website the court opinion, then it would only be in unusual circumstances that you would feel the need for that context in order to also include the private parties, opposing briefs. I think that we're making, a bigger deal out of this than is necessary, as long as the court opinions are included, and which is a part of the definition of the agency's litigation materials. And I think that was why it was important that it be included. Otherwise, it really would just be the agency's briefs without any context.
So, Robin, if I'm understanding you correctly, your suggestion, though, is that in the ordinary course, including the court opinions alone should be adequate, and we shouldn't require agencies or shouldn't recommend that agencies include, in the ordinary course, opposing counsel materials.
That's right. I mean, they should not be precluded from doing so if they think that the context is necessary, but we shouldn't have something that's almost presumes that it's necessary. And that seems to be the way that it's drafted right now.
Steph Tatum, please go ahead.
Thank you. I'm sympathetic to Judge Plager's point and to, the point that you've raised about, the trade-off that agencies might face. I think much of 5 doesn't impose a huge burden on the agency, and especially to tell litigants, a brief explanation of where they might find materials, such as opposing counsel's briefs, such as by going to PACER. I mean, I think that's fairly low burden. And it seems like E, the consider posting opposing counsel's pleadings and court opinions, is maybe the one of a slightly different character that might take it a little bit further and start to impose real costs on agencies. So I wonder if we should just pull E out of this recommendation, have it potentially in a separate recommendation, and include substantially more qualifying language around it. So such as if feasible, or if agency resources permit, something like that. So it has a greater caveat around it, and we're not saying they should disclose it, using the language of the chapeau, but we still offer them the idea to consider doing it if they have the resources.
I know that there are several members of the committee that feel very strongly about the opposing parties' litigation materials point. I guess, I'm looking for reactions to Steph's suggestion that we pull that bit out of 5 altogether and create a separate recommendation mentioning opposing parties' litigation filings, with the observation that I'm not going to be able to chair the meeting and also come up with proposed language, so I need somebody else to do it.
I mean, I think that the language would just be, agency should consider posting opposing parties' litigation filings when they are significant or important to understanding an issue. And then somewhere in there, we need some sort of caveat, such as, where resources permit. So maybe even put that in the beginning. So before agencies,
Sure.
Where resources permit, comma, agencies should consider. And then pull it out of this number 5 and make a new number 6.
I will, sure. If we want to pull it out of E, then agency should is right. Brady, I know that you had a comment.
Can I suggest that makes this issue even more of an issue by putting it down there? I think it's caveated enough. I mean, we've got the lead into from 5 saying, hey, if there's a situation where you need to put things into context, then an agency should consider doing this. I mean, it doesn't put a huge burden on them, and certainly if the court opinions come out, that's going to put context on things. But there are times where an agency has significant litigation or legal position it's taken, and there should be context put on it while the issue percolates through the courts up to the appellate courts and even the Supreme Court. And that's all this is saying. And I think, just to emphasize this, separating it into a whole other recommendation that has a number, I think makes it even more significant than we need to make it.
Point of clarification, does the chapeau in 5 have the consider language, or is it just a directive should?
I'm sorry, say again, Steph.
So in 5, those initial 2 sentences say that agencies should do the things below. So it doesn't say that they should consider doing the things below. It's telling them that this is what they should do.
Well, I think originally, so it says up at the top, it says agencies should, but I think as originally written, 5E said, consider doing this. I think it originally said, let's see, if I'm looking at 5E, it said consider posting opposing counsel's pleadings. So it didn't say that they should post opposing counsel's pleadings, just that they should consider it.
So Brady, do you have a concern with adding the where resources permit if we just kept the prior formulation and struck the agency should and kept it here?
I think we have other parts where they should consider the cost of the administration of the website. I think cost is implied. And I don't know how much cost is involved with fairness to that issue, posting the opposing counsel's briefs on a website. That's a huge burden, is it?
Muted. Steph?
I don't factually know whether it's a huge burden or not. I was trying to respond to the point, Kristen, that you made, that we don't want to discourage agencies from this endeavor altogether by adding on more than they can take on. So, I guess I'd appreciate an agency's perspective who would be posting these types of materials on whether or not it is so costly that it might deter them from doing the recommendation altogether.
Kenny Wright, I see you have a comment. Please go ahead.
Thanks. Can everyone hear me? Am I unmuted? Good. Great. Okay.
Yes, you're unmuted.
So I would just like to, thanks. Just to start, I would like to say that I very much agree with Judge Plager's recommendation to shorten and streamline this. I think it's sort of very clear, the language that he proposed. In terms of the issue of posting agency litigation material, or sort of the opposing counsel litigation material, it doesn't give me a great deal of heartburn having the language in that agencies should consider doing so. So I think having it as a subsidiary point in here seems okay. In terms of overall cost, the one thing that arises to me is that we do have a pretty robust, at the FTC, we have a pretty robust agency litigation webpage practice of having very robust web pages, but we don't typically post opposing counsel materials. I could imagine a world in which trying to do those in a very timely manner, where you have a range of folks you're litigating against, including both very sophisticated parties and also folks who are litigating on their own behalf, would impose potential obligations on the folks running our webpage to work with commission staff to review things for PII or other confidential material. I know that's addressed elsewhere in there, but I think that there is some, we of course as an agency take the obligation to review our own materials for those things, but trying to sort of in a very timely manner post pro se filings and things like that could become a problem, because we don't want to be in a position of saying, well, are they putting in PI or something like that? So that's probably a minor point that only arises occasionally, but I do think that it's good to give agencies leeway in determining which things they're going to post and what materials are actually necessary to have a full understanding of the litigation itself.
So my sense from listening to people in general, and you please correct me if I'm mistaken, is that with respect to 5E, there's general consensus that we can keep it in 5 rather than splitting it out separately. We need to keep the word consider with respect to consider opposing parties litigation filings. I guess one point that has gotten dropped in this discussion in general was Victoria Nurse's suggestion that we emphasize public significance. And I don't want to drop that point. Does anybody have any objection to including the word publicly in there? Because I think it's a valid point.
Well, I'm not sure. I don't know what it means. This is Vollmer. So if I
Sure.
understood it, maybe I would find it fine.
I guess, her point was that significance is in the eye of the beholder, and to the extent that this recommendation is in general is aimed at public accessibility. She wanted the agency officials who are deciding which opposition party comments or which opposing party litigation filings to include to think of significance in terms of what the public would be interested in knowing rather than perhaps what the agency itself thinks is significant, which, internally, which I take the point that there is, usually you would expect them to overlap, but there might be some small variation in there. Robin, I see that you've got a comment.
Yes, I think 5A takes care of this, because if you have the objective, clear, and posted criteria to determine what you're going to publish, you might indicate in that they're, to the extent, you'll describe what it is you're planning on publishing. And if you want to use the words publicly relevant or whatever you want to do, I think it's covered by 5A, and I wouldn't add it to a D or E.
Sorry, I keep having to mute and unmute. Elder Lynn, please go ahead.
Hi. Yeah, I mean, I in general agree with that. I also think that, to just sort of come back to the lead-in, the opening sentence to 5, I mean, I think that itself gives instruction as to, right, the sort of how you exercise your judgment. I mean, we still have, I think, the full and accurate picture language. And so, I'm not sure that it makes sense to add, yet an additional wrinkle within 5E.
Okay, given all of that, I'm prepared to drop publicly. It looks like Victoria has left the meeting. I know she couldn't stay for very long. So since no one else is interested in defending that position, I'm fine with dropping the word publicly in 5E. I think we need to wrap this up, but at least wrap up this 5. But I also see that we've been going for a little over an hour. So I'm going to go ahead, Judge Prager. Judge Plager, please go. Are you trying to say something? Okay, I'm going to suggest that we all take a 5-minute break, think about what's here. I'm going to kind of regroup myself, and then we'll come back and we'll walk through E one more time, and we'll perhaps vote on a few things. So let's take a 5-minute break. We'll come back at about 10:15.
This conference will now be recorded.
Kristen, are you with us?
Judge, Kristen had to drop off briefly. She's going to try to get back on. She's been getting some feedback issues. She'll be rejoining us very shortly.
Okay. Matt Weiner.
Yeah, hi, Judge.
Just wanted to say hello. How are you? How you been?
I'm very good. How about you? I'm very glad you've joined us today.
Well, we had a bit of a hurricane down here yesterday, so it's been a little exciting.
Yeah. What are you on the west coast of Florida?
Yeah. Well, I'm on the west coast, right? And the hurricane chose to, or the storm, I guess it was a hurricane category 1, chose to go offshore and then cut in just north of us, which meant we were in the right-hand quadrant, which meant we got the best of the winds and the rains, or the worst.
But you're okay?
Yeah, we got 8 inches of rain in less than 24 hours. So
wow.
Other than glug, other than not having to water the lawn, we're fine.
Yeah, well, hang in there. Did you, by the way, did you see the memorial event for Judge Williams at George Mason?
No, I did not. I missed that.
I can send you a link to the video if you like.
Yes, would you do that, please?
Yeah, I will. I said a few things about Judge Williams's work with ACUS, but more importantly, there are very nice comments from, among others, the Chief Justice and Judge Garland and so on and so forth. So I think you might enjoy it.
I would appreciate it. Please send me that link. Send it to my home email, Tricefield JP.
Got it.
Got it. Okay. When Kristen's back, I want to ask her something.
Sorry,
I'm back.
Sorry.
Oh, no problem. I'm sorry to be running a few minutes late. I decided to try to cut back on some of the feedback issues by rebooting my computer. So we'll see if that did anything. Judge, yes, please go ahead.
Kristen, I have to drop out in just a few minutes because I have another matter coming up. But I just want to make a global comment about what's been puzzling and perhaps troubling me. Let's look at the subject of the whole program. Go back to the title where after the opening text we say recommendation providing access to agency litigation materials. I don't want to be overly picky, but that's misleading. What we're really saying is providing access to materials regarding litigation in which the agency has been involved. That's a different subject. And I think if we make it clear that that's what we're talking about, we're not talking about the agency's litigation material. We're talking about materials regarding litigation in which the agency has been involved. Once we get that subject clear in our minds as well as in the readers' minds, we then recognize the need that what we're doing was we're asking the agency to come forward with a supposedly neutral position explaining not just the agency's position, which is the heading of paragraph 5, agencies should disclose materials in a way that gives a full and accurate picture of their litigating positions. That we don't mean that, except perhaps in paragraph 5. What we really mean is we want the agency to put forward on its website the litigation materials from both sides and to explain the issues, and if necessary, post the briefs from both sides, any cases that are on point, and so on. Well, if that's really what we're asking, we then have to step back and ask ourselves, is it reasonable to ask the agency to do that? My concern after 25 years of handling agency litigation at the appellate level is I have yet to see an agency that could fairly state what the opposing position was. That's not what they do. The lawyers for an agency only understand the agency's position. In fact, that's their job. Now, if you think the agency will have lawyers or other people who can neutrally put forth what it is that was going on in that litigation in the way a good law review article would do it, well, okay. I've yet to see a litigant who could do that fairly in terms of posting or even representing or even understanding the arguments and positions of both sides. That isn't what litigants do. So all I'm suggesting is we ought to get the title to this proposal clear in our own minds as well as in the readers and agencies' mind. We don't want to know what the agency's litigation materials are exclusively. We want to know what the materials are for both sides. That's what we're asking, I think. And if it is, that's a different set of issues. And the question we need to ask ourselves, is it reasonable to expect the agency to do that?
Judge,
Okay.
with respect, I don't think at all that's what we're asking agencies to do, and I think that's I think that's precisely what we're trying to avoid. Because I agree with you, we can't ask agencies to provide a neutral and balanced picture of litigation. We don't want agencies to create a mini Westlaw that demonstrates the entirety of the litigation. We just want agencies to be more transparent about their own positions. There has been discussion, a lot of discussion about opposing counsel filings with the observation that sometimes opposing counsel filings help to make the agency's litigation materials clearer. But on the other hand, I think the only thing we really, what our primary goal here really is only to ask agencies to disclose their own materials, but admittedly also court opinions, which they have access to in that way. I agree with you. I don't think it's fair to ask agencies to provide all of the litigation materials of litigation in which they are engaged. I don't think that's appropriate to ask of them, and I think that I don't think it's the focus of this recommendation. I know that there are maybe people who disagree with that, but I don't think that's what we're going for at all. So I take your concern. I take your concern, but I don't think that's that your interpretation is what we're asking agencies to do. I know that John Duffy had comments, and then I see Steph Tatum again. So John, please go ahead.
Thank you. Can you hear me?
Yes.
Yes, great. So a short comment, which is the issue of adding the court opinions has been appropriately cut out of this because it was in the previous draft that was circulated, was sort of constantly being combined with the litigation materials of the other side of opposing counsel, which is, so I agree that it was wrong to sort of couple them there. But now court opinions is sort of missing everywhere. And I think a good place to remind agencies that they really have to include the court opinion, especially if they lose, but maybe in B, where it says make sure that that the things posted are complete and up to date. I would suggest adding and include all court decisions generated in the litigation, just because I understand court decisions are expressly included in agency litigation materials. But we really do have to remind the agencies that is part of their obligation of keeping things up to date. When they finally get a court decision, that is expressly included in this. And it is true that is the court decisions themselves are things that go a little bit beyond what, to use Judge Plager's language, is really the agency's litigating position. because we have expressly included that. Obviously, the court opinion might not at all reflect the agency's litigating position, it may reflect a complete rejection of the agency's litigating position, but nonetheless, we've expressly included that, and I think that's the right approach. But I would just add in right at B this idea that to remind them of this obligation to include the court opinions, because I think that might be helpful to have reminded there. That's all. Thanks.
Unmuted. Thanks, John. I take your point about even though we define agency litigation materials at the outset as including court opinions, that there may be instances in which we ought to remind agencies that court opinions are part of the definition of agency litigation materials. Let's see, whether B is the right place to put that. Let's see, regularly review their websites to make sure they're complete and up to date. And especially that they include court opinion seems a little bit clunky to me, but I don't have a suggested alternative. So if somebody wants to suggest an alternative, I'm good with that. Or if somebody has an objection to mentioning court opinions in B, please let me know, or flag that you want to make a comment in the chat. Let's do this. I mean, we've had a lot of discussion about the opening language of 5, 5B, and 5E. I think at this point, let's start with the language of 5, and if we need to vote on it, then we can vote on it. Having listened to the discussion going back and forth, and sort of the concerns about what it is that we are asking the agencies to do, I think my own preference is to go back to, as Judge Plager suggested, just saying to provide proper context, comma, agencies should, and not talk about a fair and balanced presentation of the issues, because I think that that's getting beyond the scope of the recommendation. I think the recommendation is primarily about making the agency's position clear and asking them to provide a fair and balanced description of the issues, asks them to do something other than posting their litigation materials. That's my own view. I recognize that there are differences on the committee. I'm happy to hear comments or questions or suggestions to the contrary, but then I think we may be to a point where we need to vote on this.
Kristen, I concur wholly in your view as expressed.
Thank you, Judge. Others? Andy, go ahead, please.
My feeling about that proposed edit will turn significantly on what we do with E. So I could live with, so first of all, the objective of the language was never, I think, either in Brady's view or my view, that you had to present every argument and legal issue in the case in a fair and balanced way. It was about presenting the materials in a fair and balanced way. But leave that aside. I can live with the deletion if E retains the notion that opposing parties' litigation filings, and then I want a threshold, not every one, but I use the word significant or important to understanding an issue. That language is still there. I like that language. I think it accomplishes the objective. You could say something, well, my willingness to give up on or not to oppose any longer the introductory language is to retain this language important to understanding an issue. So the whole goal is just fairness and balance to me on significant points. So that's all I ever wanted. I won't speak for Brady, but that was the sense I had from his edits too.
And
Yeah,
this
that's
is
fine,
stuff I
Andy. I
had,
agree.
yeah, requested a comment. I feel the exact same way.
Hey, Kristen, if you want a quick fix
Sorry,
on B,
I keep getting muted because of feedback and then I forget to unmute. I apologize. If somebody could please scroll E up a little bit. I'm having difficulty seeing it because of all of the little symbols on GoToMeeting. So it currently reads where resources, so since it starts out agencies should at the top, where resources permit, consider posting opposing parties' litigation filings when they are significant or important to understanding an issue. Does anyone have an objection to keeping that language in E as it stands? Okay, I'm getting a private point of clarification here. Whether when we say here that when they are significant or important to understanding an issue, whether we're talking about understanding an issue or understanding the government's contentions. Does that phraseology make a difference? And I suppose there is, when we're talking about understanding an issue, that may be a somewhat loaded term in litigation. I guess, Andy, what do you think issue means in this regard?
The question presented to the court, either in a general way or a specific way. So it's not to just understanding the agency's position. From the very beginning, I have tried to explain. I don't see how you put in an agency's answer and not the plaintiff's complaint. I don't see how you put in an agency's opposition to a motion for summary judgment and not the plaintiff's or the other party's motion for summary judgment. So, and I don't see how you put in an appellate brief to a federal court of appeals submitted by the agency and not put in the other side's brief. And so this is, to me, part of the objective of the paper. It is principally, I agree, to provide the agency's materials. But from the beginning, for me, it was always about explanations about the law and how the agency operates, and that's how the introduction was written. So I would not want to change an issue to the agency's litigating position or whatever you propose. To me, it's broader. So I'm sorry I went on, but to me, it's a broader point.
quickly, I agree with Andy. This is Brady.
I'm fine with issue myself, especially since it's in a paragraph that specifically says where resources permit and consider. We're not asking agencies to do this in every instance. We're asking agencies, to the extent they feel they have the resources to do so, and where they think it's significant or important to, to understanding an issue, only in that instance. So, that leaves a lot of latitude for agencies. So I'm actually fine with the language of 3E myself with the word issues. Everybody else on board at this point? Okay, so I think we're gonna, from what I'm gathering, we have consensus to leave E as it currently stands, and we've got the language we're gonna have in 5. Does anybody have any objection to 5B with John Duffy's suggested addition?
Just responding, Kristen, responding to your request to make it simpler. I think if you went at B right after litigation materials posted there, you could do a parenthetical or just a clause with commas that say, posted there, comma, especially court opinions, comma, are complete and up to date.
I guess I'm wondering, so what does it mean for a court opinion to be complete and up to date?
I thought his change was just because it's a parenthetical, still leaves the agency litigation materials up to date, which I think would work. But it makes sure that it reminds the agency that court opinions is included within the concept of agency litigation materials.
Kristen, do you need me to address that?
Brady?
Yeah,
I'm sorry, Brady.
Yeah, do you need me to address
Yeah,
that?
well, I think I was muted again. So Brady, please go ahead if you want to address that.
Well, I don't think I need to. I think he makes the point. I mean, I'm open to any. I was just trying to solve that clunkiness problem, and I see what you're saying, Kristen. But I think if you're keeping the litigation materials complete and up to date, especially the court opinions, I think viewing that term as a whole and as it's defined, I think it makes sense to have that parenthetical there. But I'm certainly open to someone else making it clearer.
I think it's fine. Let's just go with it unless somebody has an objection. Okay, so we've got B, we've got E. There are a couple of other minor points with respect to 5 that have been raised. So for example, let's see. I guess with respect to G, ensure that any descriptions of litigation outside the pleadings fairly reflect the case. The ACUS staff has suggested replacing pleadings with litigation filings. Mark, can you explain what the concern or suggestion was there?
Sure. It's that pleadings definitionally encompasses a narrow subset of filings, and my suspicion, although I'll leave it to Brady and perhaps others to clarify whether this is right or not, is that what is meant in G is a reference to the broader set of all litigation materials, all of the litigation materials provided on an agency. So that would be more than just the pleading.
Okay. I don't really have any sense one way or the other. Does anyone have any problems or concerns with changing pleadings to litigation filings? Brady, do you have any objection?
Just building off of their suggestion and listening to what Mark had to say, you could just say, ensure that any descriptions of agency litigation materials fairly reflect the case. And one of the things that, I know this may come as a shock to some people, but we have seen instances of agencies gilding the lily when they describe the results of their litigation and how it turned out.
Okay, I think the suggestion is to say is to drop the parenthetical altogether and just say any descriptions of agency litigation materials.
I think so. I think that makes sense.
I like that better too. And I see thumbs up from Mark. So anybody have any objection to that change? Okay, I think we've resolved Kenny, please go ahead. Kenny Wright.
Sure. Just in terms of context, I don't know if this came from our discussions with Mark. What's been happening with our litigation web pages is that our staff will try to put a preamble beforehand to enhance web searching. So it allows folks who are interested in looking at cases covering a specific topic area or litigation or a specific statute to do that more easily when they enter a Google search. So they'll be drawn to that sort of preamble that they may not get if there wasn't that preamble there, they wouldn't necessarily be able to look at what search terms were in the actual documents posted on the website. It wouldn't be as clear. So those preambles are sort of really, at least ours are, there's no gilding the lily, and they're very sort of specifically cabined to the subject matter area. But to the extent that you were to change G to say a description of agency litigation materials, you probably wouldn't get that if you're worried about agencies who put this kind of explanatory material in, putting in something that reflects some bias about the sort of overall outcome or nature of the litigation. So that's just something to consider. I mean, I don't really have a problem with either formulation, but if the preamble is something you're thinking about, I just wanted to flag that.
Unmuted. You know, I think that may be captured in the word description. Although I'm not, you know, I think I followed your point.
It's just that we have explanatory material that's not an actual litigation material. It's neither a pleading or a court opinion. There's a preamble on our actual litigation webpage that talks about the subject matter of a specific case. So it's absolutely fine. I don't think it's a big point. I just wanted to flag that.
Okay, thank you for that. Let's see. So Mark, I see your hand and I see movement going on with respect to the language. So please go ahead.
I was going to ask Kenny whether something along the lines of ensure that any descriptions on agency litigation web pages fairly reflect the case. Does that more accurately address the concern you were just raising, or do you prefer what's there now?
I think that would address the point. So I'm really pretty agnostic. I just wanted to flag that there are sometimes material outside of the formal definition of agency litigation materials that that sort of has agency context placed in it, so agency description. But I'm fine either way.
Well, I suppose to some extent, you know, the descriptions that you are describing don't sound like there's something that would raise a concern about fairly reflecting the case anyway. I see that Robin Greenhouse has a comment. Please go ahead, Robin.
Yes, I mean, I thought that what we were talking about was a searchable database, not something where we're going to be putting in descriptions and writing up descriptions of pieces of litigation. That is a totally different concept than what I was thinking we've been talking about here.
I don't think this creates any sort of recommendation or obligation on the part of the agency to describe anything. I think we're talking about in the event that an agency decides it wants to provide some sort of description, that it needs to make sure that the description fairly reflects the case. But I don't read this at all as imposing any comment, any requirement, or even any suggestion that agencies include such descriptions. Maybe other people think differently, but I'm kind of okay. You know, I'm not concerned about creating an obligation on the part of the agency here, other than if they choose to provide a description, that they make it fair. Are you okay with that, Robin?
Yeah, as long as it's not, you know, once again presumed that you would be doing that. It just seems maybe misplaced that you're thinking about. You've already said that in your introduction that it should be, you know, fair and accurate, whatever you do here.
What about this? What if we say ensure that descriptions of agency litigation materials, comma, if any, comma.
Okay, that would be better.
Okay. I've also seen Steph Tatum has made a suggestion that I think is a good one, that instead of saying fairly reflect the case, that we say fairly reflect the litigation. Does that sound reasonable to everybody else? I think it's fine. Okay. Are we done with 5? I think we're finally done with 5, if everyone else is okay with it. Okay. Seeing no objections, then let's move on. If we scroll down a bit, we have a comment from the American Association of Law Libraries suggesting that we add a recommendation that agencies add multiple search filters by date, topic, and keyword, and that it's also helpful to list and link materials in reverse chronological order. I think in our past meetings, we have expressed concern about not wanting to intrude too deeply on web page design, given that we are not web designers. I don't know. That's my reaction, but I'm open to other reactions to this proposed suggestion. Does anybody want to recommend we add? Does anybody want to support the American Association of Law Libraries suggestion here? Robin, please go ahead.
I don't support it. I think that the more that you add particulars as to how the search term should be required, the costlier this becomes, less likely it's going to, you're going to have a web page.
I concur with Robin.
Okay, I appreciate the association's enthusiasm. I really, really do. But I think that's we're in agreement on this one, which then leads us to their last suggestion for their recommendation, proposing that we recommend that agencies provide users with sufficient information to make assessments about the accuracy and currency of legal information published on the website. I'm not entirely sure what this is getting at, and I'm a little bit leery of, this seems to me to be taking us back into the direction of wanting agencies to provide a lot of extra explanation. But again, I'd be interested in hearing whether somebody else interprets it differently or wants to support this proposal.
This is John Duffy. Can I jump in here?
Yes, please go ahead, John.
So I was initially puzzled by this, and even though I supported Robin's view very strongly about the last suggestion, this one might make sense if it's just talking about like a last updated date. So that if you see something that's on the web that says last updated 2017, and the Supreme Court finally issued a ruling in 2019, then that sort of on its face, this is not, the agency has sort of fallen off the horse and not updated things. So that might be a word. I'm not necessarily endorsing it, but I could see the value in it. It may need to just have language that's a little less opaque, that just simply says, consider including something like a last updated date, because it is often true that you find stuff on the web, lots of stuff on the web, and you kind of wonder when was this actually last updated. So I can see some merit in this proposal, and don't think it would cost the agency a lot of extra time. Something that could be automated quite easily. So I have a different view of this one than the last one. Thanks.
Sure, thank you, John. Mark?
John, just if I can get you to clarify, you think that the change you proposed fits best in this section of the recommendation? Or do you think it belongs in an earlier section? And basically, where would you like a provision like the one you just described?
Yes, thanks. I think this is what the American Association of Law Libraries is getting at, I think. So I think it's relevant to their language, though I might wordsmith their language slightly differently. This section is making it easy to find relevant materials on agency litigation web pages. You're right that it's probably even their comment seems to be not so relevant to that section.
I wonder if we could put it under 5. At the risk of
Kristen?
relitigating
I was
why.
thinking about suggesting that and feared that would make you completely.
I heard my name. Don, was that you? I'm not sure
Kristen?
who was saying Kristen. Oh,
That
Judge,
was,
please go ahead.
how does this add anything to what we've said in 5B?
That is a very good point. John, do you think that there's something that we ought to add to 5B to reflect this?
Yeah, I think it does add something, which is that 5P tells the agencies to keep things up to date, but it doesn't mention that they should actually put a little timestamp that says last updated at. Because imagine that as I think often happens, not with agencies, but with all people who put stuff on the web, that the agency falls off the horse and just doesn't update things so quickly, or just takes them time. If the agency has just an automatic date stamp that goes on there, last updated on a particular date, the user can immediately see how recent the materials are. And I think that is the American Association of Law Libraries suggestion here, and it does make a lot of sense. And it's not, unlike their last suggestion, where again I agreed with Robin, it doesn't require lots of additional stuff. It's something that probably is best practices in web design, but it's really simple.
Well, what if at the end of B, after up to date, we include a comma? And help me wordsmith here. And consider including a notations regarding when material was added or was posted?
Was last updated.
How about were last updated?
I think Judge Pleasure and I are on the same page here.
Right, were last updated.
Okay. Does that capture the point? And does anyone have a concern or alternative suggestion? I have no problem saying when material on the web page, or actually it would be on the website, was last updated. Or, I guess, okay, so Mark, remind me here, because I'm getting a little lost in my terminology. We're using the word websites in this B, but the official term is agency's litigation web page. So perhaps we need to, instead of using the word websites and website, we need to say web pages and web page. Does that make sense to people? Does anybody have any objection to this? I'm seeing nods. I like seeing nods. It's like being in class when I'm teaching and my students are nodding, and I love the nodders because it makes me feel good that everybody's on board. Okay, seems like we're good then. So that was our last comment on the recommendations. I think that we are finally done with the recommendations, unless does anybody have any other problems with the recommendations? Okay. Seeing none, I'm going to propose.
Kristen,
go ahead, Judge, please. Go ahead, please.
I would like to invite the staff's attention to paragraph 1 of the entire document. Go all the way back to paragraph 1. Can we do that?
Okay, Judge, I will say we're not done yet. We still have to go through the preamble.
Oh, okay.
So are you wanting to go through recommendation number 1, or are you wanting to go to the first paragraph of the preamble?
Is that called the preamble, paragraph 1, or is that before?
If you're at line 1, then yes, that would be in the preamble.
Okay, wherever it is, there's a definition of agency litigation materials in paragraph 1, which is puzzling.
Okay. I am open to talking about that. I think before we start the preamble, having gone for quite a little while since our last break, I think it would be useful to take a brief break for like 5 minutes and come back at 11 o'clock, and then we'll start the preamble. And then Plager's concerned about the definition of agency litigation materials.
Right.
This conference will now be recorded.
Okay, well, it's 11 o'clock. Is anybody else in the room? Okay. Excellent. Thank you, gentlemen. And ladies. I appreciate it. Didn't want to talk to an empty room. Okay, let's go to the preamble. Now, Judge, are you still with us? Looks like we may have lost Judge Plager. I do not see him listed among the participants. So I don't know what his concern was with the definition of agency litigation materials. Maybe he will rejoin us, at which point we'll go back if he does. But okay. So in that case, let's go on to the first change that I see here is lines 11, around line 10, 11, and 12. The American Association of Law Libraries suggests some additional language. The Freedom of Information Act is not an adequate alternative to accessing critical agency litigation documents that may assist in interpreting federal government guidance on key issues. This is because the time involved in preparing and submitting FOIA requests and the turnaround time for a response are barriers for many requesters, including members of the public. I guess it would go after footnote 2. On line 13 would probably be where that would make sense. Thoughts on this proposal? Go ahead, John, please.
Waiting to unmute. There we go. So I'm not strongly opposed to it, but I'd say slightly negative towards it. It seems to be sort of casting some negative feelings onto FOIA, which seems outside the scope of our mandate here, of saying things that may very well be true about FOIA and the FOIA process, but I'd feel a little awkward about memorializing such things about, how bad FOIA is. We don't I don't see why we have to say that, but I wouldn't dig in my heels on it.
Kristen, this is Robin. I would oppose it for that same reason.
Does anybody want to particularly defend putting this language in there? Or support the proposal? Okay, hearing two objections, one milder than the other, but no support. I think we drop that suggestion. Thank you both for your thoughts in that regard. Okay, so scrolling down to the next page. The sentence that is proposed, so I understand that DOJ had proposed deleting, I'm a little confused actually as to okay, that's the sentence. So DOJ had proposed deleting the sentence, but users must pay a fee for every search they conduct on Pacer and every document they view, on the ground that at least there are price waivers available for certain users. I know that ACAS staff. Mark, can you just explain to me, rather than making me try to read through and sort all of this, could you please explain to me the ACAS staff suggestions?
That suggestion is designed to account for the fact that, number one, DOJ's that it is accurate. There are price waivers. There are some cases where PACER searches are effectively free because you either have a waiver from a court or because you, in a quarter, do not exceed the $30 search threshold. In most cases, I won't even say most cases, but oftentimes, however, users can't avail themselves of either of those waiver bases. And this sentence was originally designed to point out that there is a cost barrier to using PACER. That point, I think, remains valuable, but I agree very much as a factual matter with what DOJ says. The sentence is currently written over claims, and so the ACAS edit is designed to correct that. Kristen, you're muted.
Mark, where would it go? Would it go after but users must pay a fee for every search they conduct? Or would it replace that?
It would replace the two sentences that are highlighted in, hold on for 1 second, let me pull this up real quick. It would replace these two sentences.
Yes, and what I was saying before is I do see that first highlighted sentence says, but users must pay a fee. And I gather that is not entirely accurate, although we have, one of the reasons that we have talked about, or one of the rationales in support of the recommendation generally, is a cost barrier. And it sounds as though the ways of getting out of the fees are relatively limited. Robin, I see you have a comment. Robin, you're muted now, so we're not hearing you. Still not hearing you. I'm sorry.
I guess I'll have to.
Oh, no. Oh, we just got you.
Okay. I was saying I agreed with the staff suggestion, which is to take out those two highlighted sentences and instead say, but PACER searches often cost money and the costs can add up quickly, especially when users are uncertain about what cases or documents they're trying to find. I think that is, a fairly representative statement and makes the point you're trying to make.
Since we raised this issue.
Okay. Yeah, go ahead, Brady, please. And I also saw Andy Vollmer's hand at one point.
Yeah, since we raised this issue, I think the staff suggestion addresses it. We can put a fork in that as far as we're concerned.
Great. Andy and then John.
There it is. I was just going to ask Brady for a greater understanding of the DOJ concerns. And so if he's fine and the staff's fine, I'm fine.
I'm glad everybody's fine. Okay, so John, please go ahead.
Yeah, that's right. The staff is definitely right. DOJ is right too. Just to explain the problem is I have a PACER account and I use it from time to time. I've never been charged a fee because I don't do that much on it. But so DOJ is right to say that it always costs money is wrong. What the staff correctly perceives is that there's uncertainty So you give over your credit card to Pacer and you do searches. And if you go over the $30 a month, you'll never be notified of that until the bill shows up onto your credit card. So you might, because of that uncertainty, you might really limit your searches quite dramatically. So I think the staff actually nails this one quite well.
Excellent. It sounds as though we have consensus that the staff's alternative language is a good replacement, so we'll go with that. Next, we have a comment from the American Association of Law Libraries proposing that we add language. We already talk about limited search functionality. They want to add, in addition to that, the searching capability on Pacer often makes it difficult to locate specific agency filed materials. Different district and circuit courts are not consistent with case indexing and naming conventions, making a universal search cumbersome and often leading to inaccurate results. Looking for somewhat commentary about including this additional language, whether above the line or potentially alternatively in a footnote appended to the highlighted sentence. Opposition or support, either one. John, go ahead, please.
I'm not strongly opposed to this, but it does depend upon the current configuration of Pacer, which one might hope would improve with time. So I think what we have there currently is general enough to flag the issue, but at least as currently configured, what the Association of Law Libraries says, I think is accurate from my understanding of the functioning of Pacer. One might hope it will become dated if Pacer improves, but it's probably accurate as it is now.
Andy, please go ahead.
I think we're getting all tangled up in our underwear about Pacer. And I think that the proposal from the association adds far more detail than we care about for purposes of this piece of paper. And I don't think we need it. I think what the staff's put together is plenty. And I'm just, while I'm talking, I have a similar reaction to the footnote. I think it's footnote 4. I mean, I don't think that we need to talk about pending legislation that might or might not wind up making Pacer better, especially adding a second pending bill. I mean, that talk about something that's going to be outdated in 30 days. I mean, for heaven's sakes, why can't we just say it can be improved and Congress, from time to time considers legislation to do that, or just some general statement. Anyway, I just think we're spending way too much time on Pacer.
Look, I have no objection to leaving off both this proposed addition and also deleting footnote 4 altogether. But my recollection, at least, was that from a prior meeting that there had been a request to put in a reference to the pending legislation. So, at which point, I'm a little bit concerned about deleting it altogether. I think that the request to put in the reference to the pending legislation originally came from the Department of Justice, although I'm not sure of that. Brady, do you recall? Are you still with us, Brady?
Actually and spiritually. I have, I don't remember where this came from. It might have been a solution to something someone raised. I mean, I don't mind if we get rid of that footnote entirely. As you know, and as we'll come to, we object to the last sentence in it because it seems to contradict our recommendations later, and it just does seem to be too much on Pacer.
Good. You want to delete the footnote?
Hang on. Okay, sorry about that. I was muted. I see the point about or the concern about not wanting to dwell too heavily on PACER and pending legislation that will make this recommendation seem dated before we even manage to get it through the plenary. Does anybody have an objection to our deleting footnote 4? Okay, seeing a bunch of shaking heads, let's delete footnote 4. Let's disregard or not disregard, but let's not add the proposed addition from the American Association of Law Libraries. You got to scroll up a bit to get back to it. Where did it go? There it is. We're not going to add that, I think. So there we go. So let's go to the next suggestion from the American Association of Law Libraries. So lines 35 through 37, which currently read, while paid legal services such as Westlaw and Lexis have far greater search capabilities than PACER's. Actually, I don't think that should be a possessive. I think that should just be PACER. Their costs can dissuade many individuals and researchers. The language that the association suggests adding is paid databases make access cost prohibitive to many users, including members of the public. That strikes me as just reiterating what the sentence that's already there says. But I see, John, I see you shaking your head and then nodding, and I'm not sure which one you're going with. He's unmuted.
Fair. I'm unmuted now. I was agreeing with you and disagreeing with the suggested addition. I think it's just repetitive, or I don't see why it changes anything. What's in the document right now seems fine.
Does anybody want to support the association's suggested addition? Okay, seeing none, let's not take it up, or let's not follow their suggestion, and let's move on. So Alan Morrison has proposed some additional language. Mark, I'm not entirely clear where Alan's proposed language would be added. I don't know if you can highlight a sentence, but Alan proposes, I remember we had discussion about this at earlier meetings, that there were questions about agency access to litigation materials where DOJ was handling the litigation. And Alan's proposed language says, when an agency appears in court, it can request that one of its officers or employees be designated as a party representative in the court's case management electronic case files CM/ECF system, giving the designee automatic access to filings made in that case. In that way, among others, agencies can obtain full access to litigation filings in cases to which they are parties. I think that's factually accurate. My understanding, Brady, my understanding is that Department of Justice has agreed that language, at least something kind of like that, is at least factually accurate.
I mean, it's accurate, but I just think it's unnecessary. I mean, why do we need to put that in this document? I don't know what it's suggesting or what problem we're addressing by putting it in there.
Mark, please go ahead.
Context.
You're muted.
Believe am I unmuted now?
No,
Yes,
now
no?
you are not muted.
There we go. I believe at a previous meeting, the topic came up about how easy or difficult it would be for agencies to actually compile their litigation materials or have them on hand so as to post them on a litigation webpage if they chose to create it. At the time, I think there was some confusion about how, the extent to which party agencies that are clients of DOJ, whether they would have to jump through any particular hoops to get a hold of their, litigation filings made in their names. My opinion on this is irrelevant, but until that meeting, did not view this as an issue. I think I understand Alan's edit here to be in response to that discussion, though, if that jogs anyone's memory.
So Alan is not here to defend the inclusion of this. In Alan's absence, I suppose Mark's description does resemble my recollection from past meetings. And I think there was some confusion or some concern on the part of some agencies about whether and to what extent they would have access to materials. I don't know that it necessarily adds anything to the recommendation, but to the extent that there was, I guess the question I would have is to the extent that there was concern expressed by some agency members at past meeting about whether they could access these materials or how they would have access to these materials. In order, to the extent that the preamble is at least partly about marketing the recommendation, I wonder whether at a minimum footnote with recognizing language, something, recognizing this concern, it might go some ways toward assuaging any agencies that have a similar concern to that expressed in the prior meeting. So Robin, please go ahead.
So Kristen, I here representing the IRS Office of Chief Counsel, I know we expressed this concern with respect to litigation that the Department of Justice handles on behalf of the IRS Commissioner. And I don't find this particularly useful because the agency is not making the appearance in court. It's the Department of Justice, once again, that's making the appearance in court. I think that this implies somehow that we should be doing this and making some sort of representation to ask to be included in the system. And I think that we wouldn't agree with that implication.
Okay, Robin, that's very helpful. Thank you. Like I say, since Alan's not here, I feel the need to at least offer some support, but at the same time, I don't feel strongly one way or another. I take Robin's point. Does anybody else want to speak one way or the other about Alan's proposed suggestion, whether above the line or as a footnote? Go ahead, John, please.
I think it is somewhat confusing. There's no preamble to say why we're including it. It also refers to getting all the filings made in the case, which again is something that we've discussed extensively today, that the agency's basic obligation is not to make access to all the filings or to get them and put them on its website. It's just their own materials plus including the court opinions. The other thing that I think is kind of odd is, and this seems odd, that the easiest way for an executive branch agency to get its own filings is to actually ask the Article 3 court to let it into the Article 3 maintained system, rather than to just ask the executive branch agency that is its lawyer, the DOJ, to give them copies of them. So I'm kind of, again, I wouldn't dig in my heels, especially if it were just a footnote. I think it's a little confusing.
Okay, here's my proposal. Go ahead, please, Matt.
I don't sense any support for Alan's position here, and I assure you that Alan's feelings will not be hurt. They never are.
Thank you, Matt. I was actually just going to say that my sense is that there's no support for including this language. And so if Alan wishes to bring it up at the plenary, he can bring it up at the plenary, and otherwise we will move forward. Okay, so scrolling on. Hey, we're getting there. Okay, so our next, hang on, my all of my paperwork just got jumbled up. So, because I was looking for a piece of paper. So our next thing here, Mark, can you just very quickly summarize what's going on here? There are lots of little words on this page.
There we go. What I think is going on here, and Brady, you're going to have to correct me if I misinterpreted your edit. My understanding is that the comment from DOJ was meant to reflect the fact that the language initially proposed by DOJ, which is currently highlighted, is effectively subsumed in the recommendation, the changes made to recommendations 3 and 5, so that this proposed language, everything that's currently highlighted, is no longer necessary so long as the changes to recommendations 3 and 5 are embraced, which they have been. Is that fair, Brady?
Perfect. Put a fork in this one. We're done. We're good.
So is the proposal just to delete these lines? Okay. Does anybody feel the need to keep those lines? Do we need to put them back up so people can read them before we decide definitively to delete them? Going once? Going twice? Deleted. Okay. Moving forward then. Okay, in addition to line 72, the sentence currently reads with the addition, an agency that litigates thousands of cases each year, for example, could justifiably choose, and the proposed addition is not to create an agency litigation webpage at all, or choose to feature only a representative sample of agency litigation materials on its agency litigation webpage. The addition being not to create an agency litigation webpage at all. I will note that I think just a few sentences later, we specifically recognize that agencies will have the option where they think it's appropriate not to, that I guess it's lines 92 and 93, we specifically say this recommendation should not be read to suggest that every agency create and maintain an agency litigation webpage. So consequently, I wonder if, I'm a little troubled by the negative tone of this addition. Right off the bat, hey, but you don't have to do this. We're going on and on about these reasons for creating an agency litigation webpage, but we say, but you can choose not to do it. I think my own preference would be to be more positive and to talk about how it might be done, and then acknowledge, as we do a few lines later, that that they have the option of not doing it at all. But that's my own view. I welcome other thoughts, suggestions, concerns, either in support of or against this proposed edit.
Been here, and I don't know if we've looked at this before. There is an ACUS recommendation that deals with agency adjudication materials, in which we contemplate this problem of agencies that have very high volume of litigation, in that case internal litigation. And I don't have it in front of me. Maybe there's some language there that would be useful. Not sure. Reeve, do you or Mark, is there anything useful there?
Well, I think what we did there was something like encourage the agencies to post like a representative example of the sorts of materials that they confront, in these repetitive sorts of cases. I'll take a look at it, but my recollection is we did something like that. If the committee wants to consider doing something similar here.
So
Mark,
I can jump in here. Yeah, in fact, that's exactly what we did. We have a footnote in the next paragraph, I believe, referring to exactly that recommendation. It was 2017-1. And the language in this recommendation largely cribs from that. That's in response to comments made, I forget at the first or second of these meetings, but that language has been largely built into this one.
So given all of that, I'm wondering whether, I mean, Brady, you're here from DOJ. Do you want to offer a suggestion as to why the proposed edit in line 72, in light of all of the sentences that come after that, why we really need this additional clause?
Well, I think it's first of all, it's consistent with the entire recommendation. We should make it explicitly clear in that circumstance that it's perfectly acceptable not to create an agency web page. And when you perform the analysis that's called for by the recommendations, it leads to this conclusion for an agency. And I think we should, especially when we're looking at the costs of putting something like this together, I think it's important to have this clause in there. I mean, it's a qualified example. It sets it out, and I don't think it's redundant. I think it supports the later sentence which you identified. I'm not sure which line it is now, but on the next page, it was on 92 to 93.
Yeah, it's now at 82 to 83, I think.
Right. Yeah, I mean, we have it in there. I think in this situation, it's important to us to have it in there to make sure that our circumstances are set forward. I mean, otherwise, I think that the ACUS is going to be open to criticism of putting this potential mandate on agencies. When I talk to people in the agency, they said, well, looking at the volume of what we have here, it would cost tens of millions of dollars for them to try to create, a full agency webpage with all of our litigation documents. I don't even know. I mean, you'd have to create another Westlaw in order to capture everything we're involved in. We have 33,000 active cases.
So in other words, if I'm understanding you correctly, you're saying that 82 and 83 are inadequate to task.
Yeah, I think it's important that we set forth exactly our circumstance and our situation. And I think while they're similar, I think they say two different things.
Unmuted. How about this? I mean, my concern again is that I don't like leading with choosing not to create an agency litigation webpage. How about at least moving the proposed edit to the end of the sentence so that an agency that litigates thousands of cases each year, for example, could justifiably choose to feature only a representative sample of agency litigation materials on its agency litigation webpage, or could or not to create or choose not to create an agency litigation webpage at all. Is that an acceptable compromise?
Thought I was unmuted. Yeah, that's perfectly fine. That's acceptable.
Other concerns that people have with that? I mean, I will readily concede I'm still not crazy about it and might at the plenary session. Well, I guess since I'll be chairing it, I may not be able to do that, but I might find somebody at the plenary session to object to that language because I find it problematic as leading, given everything that's gone later. I feel like while we have given lots and lots of flexibility to agencies, I think it creates a negative presumption right off the bat, and that makes me very uncomfortable. John, go ahead, please.
Yeah, I somewhat agree with you because I think there's a thought that is in the later paragraph that says it involves balancing factors. And that thought is not immediately apparent in this sentence. This sentence seems to, or it could be read to just say that if there's simply a lot of litigation, thousands of cases each year, that in and of itself makes it appropriate for the agency not to create an agency litigation webpage at all. Whereas I think the later paragraph deals with, requires the agency to go through a balancing test, which I think is more appropriate. It may be certainly the more litigation you have, the more that's going to raise costs, and that's certainly a factor. But the more litigation you have, there's also going to be perhaps more public benefits for the web page, so that has to be factored into the balance. So I'm somewhat opposed to putting this language in where in this particular sentence. I'd rather just leave it to the balancing test later. Thanks.
Kristen, Robin, could I respond? Kristen, you're muted. You're muted, Kristen. Can you hear me? You can hear me now? The word that bothered me in this sentence, that's why I wanted to have the other side, was justifiably. When you say justifiably choose, makes it sound like it's not justifiable to choose not to have one. And so perhaps if you take out that word and just say could choose only to feature the representative sample, that makes me feel better, knowing that then several lines later you're going to say there's no, that there's no presumption that you have to have one.
I think that's a very helpful suggestion, Robin. Thank you for that. Brady, I know you were next.
Here, I'm okay with that, or just maybe even removing that clause and adding to 82 to 83. This recommendation should not be read to suggest every agency create and maintain an agency litigation webpage, comma, especially where an agency litigates thousands of cases each year. Or especially agencies that litigate thousands of cases each year, something along those lines.
Let's see. It's a little, I take the point. Maybe it's a little clunky as worded, so I'm trying to figure out how to unclunkify it. Should not be read to suggest that every agency create and maintain an agency litigation webpage. Maybe just
each year.
I'm sorry, say again, Brady?
So it would read at the end of that, especially agencies that litigate thousands of cases each year.
Yeah, it's not quite grammatical is the thing. Let's see. Should be read that every agency create, and should not be read to suggest that every agency create and maintain an agency litigation webpage. How about especially when an agency litigates thousands of cases each year?
You could flip around. The other thing you could do is flip around the subject and the object of the verb of the sentence, of that clause rather, and say this recommendation should not be read to suggest that agency litigation web pages be created and maintained by every agency, especially agent, and then it would work. you switch it to the passive voice, which is usually bad, but it makes sense here because you actually need to put that
I like
final
that. I like that, John.
I once was an editor for.
Well, we do both write for a living.
That's
Robin,
true,
did you
too.
have something you wanted to add here?
No, that was fine. I did sign off in a couple of minutes.
Sorry, the muting and unmuting is getting to me. So I think we're all agreed then that we can delete the clause in that was just deleted in line 73, and that I'm not, John, I don't think we've picked up your proposed alternative wording, but people seem to like it better than what was there. So can you walk Mark or whoever is keeping track of this through it one more time?
Sure, I'll try. Let's see. This recommendation should not be read to suggest that agency litigation web pages be created and maintained by every agency, or maybe you should say by all agencies, especially those that litigate thousands of cases each year. I think that's clear and a little less clunky.
I like it better. Brady, are you okay with that?
And especially if you're not going to stand someone up to oppose it in the plenary.
I will go along with this. Thank you.
Let's just
Okay.
make DOJ is cool with this. We don't want to litigate this at the plenary session. Speaking of litigation, and there are other agencies like Social Security that are going to have something to say on this. So
I have no interest in litigating this on the plenary floor. I really, really don't, and I am fine with this language. I totally take the point. I agree with respect to SSA, with respect to IRS, with respect to BIA. There are lots of agencies that are going to be in this position. I have no problem reflecting the point in the recommendation. I just didn't like the placement of the one clause up in line 73. That was my only objection. And I think if we're all happy with this fix, I think it captures the point, but it captures it in the appropriate place.
I agree. It's improved. Thank you.
Wonderful. Thank you, everybody. I greatly appreciate it. Okay, so scrolling down. Okay, so it looks like, if I'm reading this right, Mark, this is just, sort of a note of what we've talked about before and is now no longer necessary, or is this proposing we delete something?
I think you're correct, Brady. Again, I'll look to you for information.
Yep, we're done with this. It's good. It's fixed.
Fabulous. Let's delete the comment and we're moving on. And we're to the end of the preamble. So folks, I think we've done it. Does anybody have any further thoughts, comments, suggestions, concerns, etc.? Okay, hearing none, then my understanding from Matt is that we need to take a vote as a committee to move this forward as written. Is that correct, Matt?
yes, and I think that I think you could just I think it would be fair just for logistical purposes if you just want to ask the committee members if they have any objection to the adoption of the recommendation. I think that probably would work, or you could go committee member by committee member. But the important thing is that only committee members should vote here.
Unmuted. I'm fine with doing it by, asking if anybody has an objection. Does anybody have an objection to moving this recommendation out of committee and moving it forward? Seems like everyone is on board. So with that, I want to say to everybody, thank you. It has been a rough 3 meetings, getting this plus additional consultations, getting this recommendation through. But I think it's in really good shape to move to the plenary floor. And I just can't thank you all enough for everybody's attention and concerted efforts in this regard. And with
Quick,
that,
and
unless
also, I think it would be, I think I could probably speak for everyone when we say that we all thank you for slogging through this one with us and getting this done. And I think I think this process reflects extremely well on ACUS. And the comments here and the contributions today, I thought were really kind of exemplary. And I do want to thank in particular the Department of Justice and Brady in particular for working with ACUS in so constructive of a way.
Hey, well, Matt,
I absolutely concur with that.
Yeah, I concur. We're really happy about how productive our engagement with ACUS was on this, and we're really pleased with the product. So thank you all. Thank you very much.
Thank you, everybody. And with that, I will look forward to seeing everyone at the plenary. Thanks so much and have a good afternoon. We are adjourned.